The Equal Rights Amendment, or ERA, has a long and complicated history. It was first introduced in 1923 by Alice Paul. Paul was a prominent suffragist. She had fought hard for women's right to vote. Paul believed that true equality required a constitutional amendment. The ERA aimed to guarantee equal rights for all citizens regardless of sex. The ERA was introduced in every Congress after 1923. It faced significant opposition. Many feared it would disrupt traditional gender roles. However, the movement for gender equality gained momentum in the 1960s and 70s. This led to a renewed push for the ERA's passage. In 1972, Congress passed the ERA and sent it to the states for ratification. The ERA needed approval from 38 states to become part of the Constitution. Initially, there was strong support. 22 states ratified the ERA within the first year. However, the ERA soon encountered fierce resistance. This opposition was fueled by concerns about its potential impact. Some feared it would lead to radical social changes. They worried about women being drafted into the military. Others believed it would threaten traditional family structures. As the debate intensified, the pace of ratification slowed down. Congress, recognizing the challenges, extended the original ratification deadline from 1979 to 1982. Despite this extension, the ERA fell short of the required 38 states. Only 35 states had ratified it by the 1982 deadline. This sparked a debate about the validity of the deadline and whether the ERA could still be adopted. Opponents argued that the deadline was final and the ERA was no longer eligible for ratification. Supporters, on the other hand, pointed out that other amendments had been ratified after their original deadlines. They argued that the ERA remained viable. The legal battle over the ERA's deadline continued for decades. The issue remained largely dormant until recent years. However, the fight for gender equality continued through other avenues. Advocates pursued legal challenges to discriminatory laws and policies. They sought to achieve equality through legislation and social change. In a remarkable turn of events, the ERA gained renewed momentum in the 21st century. Fueled by the growing movement for women's rights, Nevada, Illinois, and Virginia ratified the ERA between 2017 and 2020. These ratifications, although occurring after the 1982 deadline, brought the total number of states supporting the ERA to 38, meeting the constitutional threshold. This sparked renewed debate about the ERA's status. Proponents argued that these recent ratifications should be counted, making the ERA the 28th Amendment. Opponents continued to maintain that the 1982 deadline was final and the ERA could not be revived. The legal and political battle over the ERA's ratification continued. Supporters filed lawsuits to compel the Archivist of the United States to certify the ERA as part of the Constitution. Opponents challenged these lawsuits, arguing that the Archivist lacked the authority to do so. In 2025, President Biden issued a statement declaring his administration's recognition of the ERA as the 28th Amendment. While this declaration was largely symbolic, it sent a powerful message of support for gender equality. The president called on Congress to affirm the ERA's ratification and to remove the 1982 deadline. The ERA, if recognized as a valid amendment, would have far-reaching implications for gender equality in the United States. It would provide a constitutional basis for challenging discriminatory laws and policies. The ERA could impact a wide range of areas, including employment, education, healthcare, and family law. The ERA's potential impact includes guaranteeing equal pay for equal work, prohibiting discrimination based on pregnancy, and ensuring equal access to opportunities in education, athletics, and the military. It could also strengthen legal protections against gender-based violence and discrimination. The ERA's recognition would be a historic milestone in the fight for gender equality. It would send a clear message that discrimination based on sex is unacceptable and unconstitutional. The ERA's impact would be felt for generations to come.